Good morning, guys. Welcome to Shanzu, Mombasa. My name is Jami, part of the prosecution team. I am here present with Ms. Ogega. Maybe you can introduce yourself fully.
Yes, hello, I'm Ms. Paris Ogega. I'm a senior prosecution counsel and I'm based here in Shanzu.
Well, my name is Mr. Anthony. I'm prosecution counsel, president of Council of Courts. Currently handling this matter involving Mackenzie and others.
We are just three, but we are part of a team of more than 10 prosecution counsel, handling at least 4 cases. That is murder in Malindi, manslaughter in Mombasa law courts, and last week, or is it 2 weeks ago, we had children offenses at Tononoka, and today we are here in Shanzu, radicalization. Now, to introduce this particular case, we have the offense of organized crime under the Prevention of Organized Crime as the main offense. And then we have offenses under the Prevention of Terrorism Act, particularly the offense of radicalization under 12D. For those guys who might not have had an opportunity to prosecute an offense under POTA or in particular radicalization, it is simply the adoption or promotion of an extreme belief for the purposes of advancing or facilitating ideologically based violence. In this particular case, it was death, and the purpose is to advance social, political, or religious change. Now, we have 95 accused persons, and we have grouped them into 2. The first group is the biggest responsibility bearers, who are the promoters, and then we have the adopters. Perhaps now I can hand over to Ms. Ogega so that he can talk a little bit more about the case in terms of fleshing it out.
All right. So what I'm going to talk about is what transpired for the first week of hearing, especially the number of witnesses we called and how they performed. So we had intended to call 2 witnesses per day for the 4 days of hearing. Unfortunately, or I think it's a success, we went through 5 witnesses. And the nature of the witnesses was that 1 was a protected witness, 1 was a minor, 2 are civilians, and 1 was a police officer. So the first witness took 2 days for us to conclude his testimony, and we hadn't anticipated that the witnesses are going to take this long. We thought we would get through 2 witnesses in a day, but we ended up having the first witness take 2 days. And the main issue was that the main reason why the witnesses took long was that first they were breaking down, they were quite emotional, and I'm sure you can appreciate that this is a very emotional case given that they lost loved ones and they lost so many children. So they were breaking down and we had to take breaks to enable them to recover.
Yeah.
Yes. And then secondly, we have 3 defense counsel and all of them wanted to cross-examine. So we had quite lengthy cross-examinations and that's why it took long. So that is what transpired in regard to the witnesses. So the issues that arose is that we discovered that given the way this case is impacting our witnesses, we need a resident counselor to be sitting in court and after the sessions to be counseling our witnesses, because all the civilian witnesses broke down. In regard to the accused person who died, it was a lady. She was the 57th accused person. And the route we decided to take is to dispose of the matter by way of an inquest. This is in regard to the law. I think it's section 387 of the Criminal Procedure Code, which states that when someone dies while in custody, a public inquest must be done. So currently, investigations are taking place. We have had our investigating officers go to the prisons and record statements. I think the post-mortem is to be done today. so that we can bring the matter to court for a public inquest. So that is the step we decided to take with the accused person who died while in custody. So I think I'll hand over to Mr. Musyoka to be able to give us our case theory.
Thank you. Once again, I wish to say that as drivers of justice in the path of this extreme belief that appears to have been orchestrated by Mackenzie and others by adopting an extreme belief which had as single purpose to advance a political and religious change which was highly promoted at an area within Malindi, in a specifically location known as Shakahola. Within this week when we took up the first witness, we were able to first bring to the attention of everyone, including the accused persons of the court and the defense, that one, there was discovery of what took place by the first responders within Shakahola forest. It is within that time that even relatives of part of the victims were able to know that certain events took place. And that was the evidence that we were trying to bring to the court and for everyone to know that these occasions, these acts took place. Subsequently, we will have another hearing come next session, which will be our second session. And in that session, we will be now keen to bring out to the attention of everyone that one, there was a proper organized system of by Mackenzie and others to ensure that people would go in at Shakahola forest, and therein they would adopt his belief and subsequently would not leave upon entering that. That would mean then the area had security or was manned by security men who were able to control and limit movements from one area to another. There down, we will also be bringing to the attention of the court that place is far away from the main town known as Malindi, and people could not access the place by walking. So there was organized means of transport, which was organized by the main party, or the main parties involved in this case. And further, we'd also be showing the court that people had a way of dying. That is, once they adopt the belief, subsequently they would die by a system that was well orchestrated by Mackenzie as his senior team. People had to be wrapped and placed in some particular areas. That is where we indicated to the court as canopies. And once one dies, was to be carried or ferried and placed in a secure place or in a grave. Thirdly, we will have a third session and other sessions thereafter. So, but for now, I can mention the third session, which we will bring to the attention of the court to show how people were radicalized and how Mackenzie was able to facilitate the movement of these people who had been radicalized before they moved to Shakahola, which we will be showing that indeed much and part of the radicalization took place within Malindi in an area known as Terrorism. So for now, I can say that, and thank you. I can hand it over to my senior, Mr. Jami.
Okay. So we will get much more information about this particular case. I refer you to the opening statement that we made. Let me also add that we have 90 witnesses for this particular case. Now, those 90 witnesses are broken down simply into civilians, police officers, that would be arresting officers, crime scene officers who have crime scene reconstruction, and those who led the exhumation process. We also have experts, opinion experts, and we have also forensics experts. What we are discussing right now with my colleagues and the larger team is we are trying to explore a way by which we are able to actually prove or establish our ingredients with fewer witnesses. If we could be able to close this case at 60, if possible 70 witnesses, that is now what we call a continuous review of the decision to charge. We have to keep on reviewing the progress of our case and making adjustments so that we can address some of the issues and challenges arising. Now, lastly, for those who might be wondering why we have 4 cases, it is simple. We have this case where people adopt and promote extreme beliefs. Then ultimately we have death. So the death is being handled in the manslaughter case and in the murder case. And now someone else might ask why manslaughter and murder. There was a suicide pact by which everyone perished. But we also say that because a suicide pact is an agreement between people who sit and agree and decide to take their own lives, children could not have possibly been part of that suicide pact by reason of capacity, that is the young age and criminal responsibility. So in respect of those offenses that resulted in death of children, we have now the murder case. We also have kids who survived, so that's why we have the case in Tononoka. So cruelty, denial of food, assault, crimes amounting to torture against the child. And then we have crimes amounting to, infringement of social rights, basically education. So we have an offense under the Basic Education Act. Is there any other offense? There are around 17 counts. So we are putting it at around 6, 7, 8 child victims, or around 10, right? Because of the 17 crimes. Some of them are 2 counts against 1 minor. We invite you guys to follow this journey through, and if you guys have any views that you would like to share with the prosecutors as we go along, you can always get in touch with Mr. Musyoka, Ms. Ogega, myself, and then we have our team leader, Mr. Kiprop. Yeah, so pick the interest and enjoy the journey. Thank you.
Thank you.
Thank you.